Hi, good morning. Good morning. Come in and do take a virtual seat. We'll just wait for everybody to join us and then we'll get started bang on past. All very welcome. Hello, good morning. Good morning. I hope you've all had a pleasant journey here today from your kitchen or wherever it is your commuters these days. Okay, I think we will get started. Good morning and welcome to a very jolly hour where we're going to be examining the recent Uber ruling. I'm Elizabeth Smith, I'm the Director of Research here at BFI, and before we actually start, I'm going to pass over briefly to my colleague Ellie, who's our tech support for today. And for anyone who's not familiar with Zoom, and I can't really believe at this point that anybody isn't, but she will talk you briefly through how to engage with us today, and she's here all morning. So if you do have any problems with sound or vision, please message her directly, or my colleague Sam, who's also here, in case you need anything else as we go through this morning. Over to you, Ellie.
Hello, everybody. Welcome to this morning. I'm really excited to get started. Like Elizabeth said, most of you have probably used Zoom before, but just in case we want to go through a few things. This is a webinar and not a meeting, so your video won't be shown, but at the bottom you should still have options available to you. One of them is chat. So if you want to send over some general chat, that would be great. And in fact, if we could have you get started by just popping in the chat where you'd rather be this morning, because that lets us know that it's working for you and that you're happy doing it, and kind of gives us a little insight into who our audience is today. Well done, Wendy. Yes, me too. And the second button that you should take advantage of if you can is the Q&A button. So if you can keep general chat to chat, and if you have any questions, just pop them in the Q&A and we'll answer them as we go. So I hope that explains everything that we need doing over here. If you need anything else from us, please go ahead and, like Elizabeth said, get in touch with me. I'm Ellie Roper, or BFI admin Sam Travis is here for you as well. So back over to Elizabeth to start the show.
Thank you, Ellie. We are in August company today. Actually, we have an outstanding speaker lineup, which includes the lawyer who represented the original lead claimants of the case, the author of the independent Taylor Review of Modern Working Practices, IR35's most prominent thought leader, and the author of CEST Explained, and a member of the Cross-Government Working Group on Employment Status, who published a review into the taxation of the gig economy. On the 19th of February, the UK Supreme Court handed down a decision about the worker status of UK Uber drivers. The case first came before a judge in 2016, so a lot of UK employers and workers were watching closely for this decision. The ruling means that UK-based Uber drivers are entitled to employment rights such as rest breaks, holiday pay, and a minimum wage. And the court's findings will affect the UK's entire gig economy, including international businesses with UK operations. So it fundamentally changes how UK businesses should assess worker status. With HMRC recognising two tax categories and UK Law 3, along with recent IR35 changes, UK employers do need to be careful because getting it wrong could be costly. Our first speaker this morning is Paul Jennings, who's a partner at Bates Wells, which is the firm that represented some of the claimants. Paul advises companies, charities, LLPs, and senior executives on all aspects of employment and partnership law. His day-to-day practice involves dealing with the full range of employment law and partnership issues, ranging from negotiating complex contracts to pursuing and defending high-value claims. Paul has a particular interest and expertise in the law on status and discrimination, having fought a number of the defining cases in these areas. Paul's going to give us a legal analysis of the ruling and talk about what this really means for Uber and other gig economy employers. Please do post your questions in the chat as we go, and we will come to them at the end of his session. Paul, welcome.
Thank you very much, Elizabeth, and it's very nice to be with you today. As Elizabeth said, I acted for the test claimants in the Uber case up to the Supreme Court, and before that I'd acted for a number of gig economy workers in the preceding 5 or 6 years. So I was involved in the City Sprint case, in the Addison Lee case, and a number of others. But we, Bates Wells, are a city firm. Predominantly over 80% of our clients are businesses and charities. And despite running this case, most of my time is spent advising on the other side of the picture. So employers coming to us, asking us about status issues. And I say that because although I have a very clear position on the rights and wrongs of the Uber case, I see the other side, and I hope that introduces a degree of balance into what I'm about to say. You've got a really fascinating lineup of speakers who are going to debate the issues and discuss the issues. My role is really to give a thumbnail sketch of the law, a sort of a primer or introduction to the discussions, just so we all have a framework or a basic understanding. So that's what I'll do. I'll set out what the law says, how it works, and how the Uber judgment fits into that overall structure. So the legal framework around status is deceptively simple. There are, as Elizabeth said in the introduction, 3 basic categories for employment law purposes. You're either an employee, a worker, or you're self-employed. Those are the 3 options. And that creates a form of hierarchy. At the top, you have employees who have a fairly significant suite of rights and protections that apply. And that recognizes the fact that we spend most of our waking lives at work. There is an imbalance of power as between us as individuals and the organizations that employ us. And those statutory protections have grown up over time. They oscillate depending on which government is in charge and what social policies are predominating. But by and large, it's a heavily protected category. So that's employees. On the other end of the spectrum, you have the self-employed, and the self-employed have almost no protection whatsoever. They're deemed to be commercial entities who ought to be able to fend for themselves within a commercial marketplace. You then have the middle category of worker, which is what all of the cases in recent years, over the last, let's say, 5 to 8 years, have been about. The worker category, the intermediate category. If you're a worker, you have access to a basic suite of rights: minimum wage protection, the right to paid leave and rest breaks, protection from unlawful discrimination, and protection from detriments if you blow the whistle, the right to participate in collective bargaining, the right to be consulted in the context of a TUPE transfer, and enrolment into a pension scheme subject to age and earnings criteria. So if you're a worker, that isn't an extravagant list of rights. They're the sort of rights you would hope anyone you cared about had access to. But nevertheless, that has been the battleground because those rights cost. They cost organizations. And if you can take free of those rights, if you can avoid them, that confers on you a very significant competitive advantage. And that's why we have all seen in the case law over the past 5 to 10 years, a fairly concerted effort by companies of all sizes, attempts to manipulate the boundaries that demarcate each of these roles, and in particular, the boundary between worker and self-employed. There has been concerted and systematic attempts to manipulate that boundary. When I started out in practice 15 years ago, it was the other boundary line that tended to be the focus of employment disputes, whether people were employees as opposed to workers. And that has shifted over time, and now we're debating the second boundary line. And I think that represents a dilution in employment protection. It's also indicative that the workplace has become more fluid. So that's the bigger picture. What is the test for who is a worker? What test is the court applying to try and ascertain whether somebody is in the middle category and subject to that basic suite of rights, or are self-employed? Well, there are 3 tests. The first question is there a contract? That's test 1. Is there a contract? Test 2 is there a requirement for personal service? Does the person, the worker, the putative worker, have to provide the service themselves? And thirdly, and I'm paraphrasing, this is what is sometimes referred to as the LIMB proviso, is the relationship a commercial relationship, or is it more in the field of dependent work? So are the parties essentially two commercial outfits, or is it more akin to a dependent workplace relationship? Those are the three tests that the courts have to work through to ascertain if somebody is a worker. And generally speaking, test one has not been the predominant test. Is there a contract? Has rarely posed a problem. But that's what Uber was about. It's centered on test one. Is there a contract? And I'll come back to that. Test two, is there a requirement for personal service? There's a lot of case law around that. And that's why you see a lot of contracts that have substitution clauses, because substitution clauses tend to be a silver bullet. If somebody can genuinely, in an unfettered way, send along a substitute, that will defeat any claim that they're a worker, and it will place them firmly within the category of a self-employed individual. Matthew will speak later and has spoken, I think, very sensibly and eloquently on the difficulties around substitution clauses. But the third test is around what is the nature of the relationship? Is it essentially an arm's length commercial relationship in which the individual is conducting a business, or are they in actual fact subordinate, dependent, and very much like an employee in most respects? So I said at the beginning that the first test, is there a contract, doesn't tend to get litigated because normally it's very obvious there's a contract. But in the Uber case, what Uber said is, well, there is no contractual relationship between the drivers and Uber London Limited. They said that the contract was as between the driver and the passenger, and that there was no direct relationship between the driver and Uber London Limited, the UK-based entity. It was a novel argument in the sense that it sort of made a nonsense of their structure. Uber London Limited was the regulated license holder. It, in reality, was the entity that hired, onboarded, trained, disciplined, and managed the day-to-day functioning of the business. So the idea that there was no contractual relationship as between Uber London Limited and the driver didn't correlate with reality. There was a Dutch entity which held the license for the software, and that was the entity that Uber were keen to highlight held some form of contract with both passenger and with drivers. But they were, with a straight face, trying to say that Uber London Limited had no contractual relationship with the drivers. So Uber is a case, if you're interested in test one, is there a contract? The test around whether there's personal service, that there are a host of cases on that, but the Deliveroo case is the only example that I'm aware of a gig company successfully arguing that individuals were not workers for the purposes of employment law because they had an unfettered right to substitution. And there, the Central Arbitration Committee held that Deliveroo riders could, in an unfettered way, in an unrestricted way, simply give work to a substitute. But it's really interesting looking at the judgment of the CAC, because Mary Stacey, the judge that presided over that, said, well, what on earth is the point in the CRB checks and the hygiene training and all of the effort that goes into ensuring that the people transporting food from point A to B are so heavily trained? Why have these systems? Why have these standards? If the food can be given to anyone willy-nilly without any of that training having real world significance. But that second test around personal service is a Deliveroo type case. And then the majority of the cases that you see really are in the third category. What is the nature of the relationship as between the putative worker and the engager? Is the individual in business? Or are they in fact in a dependent work relationship? So what did the Supreme Court have to say? The case at first instance was heard by employment judge Snelson, and his his judgment is worth a read. It's full of thinly veiled anger and frustration, because what he was saying is this is a confection. All of the documents have been drafted not in an attempt to accurately characterize the relationship as it is and to give the parties clarity over their rights and obligations. And that is the normal purpose of a contract, to define as clearly and as accurately as you can what the expectations, obligations and rights are as between the parties. What he said in a 50-page, quite angry judgment is that this is a work of fiction. The language is Delphic and opaque, and the roles of the relative parties have been mischaracterized, and all of that is intended to give the impression that Uber is nothing but a technology company, and the drivers are essentially in business on their own account. And he said that was a nonsense, that these people were dependent upon Uber for their living, that they were integrated into the fabric of what was a transport business, not an IT business, that the only way that they could make more money was by spending more hours behind the wheel, that there was no opportunity for entrepreneurial flair or for these people to make a success of their business. They were in that highly dependent relationship that most employees are, and therefore that they should benefit from the basic protections that statute provides. The case went up to the EAT, and Jennifer Eady, the High Court judge sitting at that instance, agreed with the first instance decision, and then it went up to the Court of Appeal. And there was a 3-panel set of judges in the Court of Appeal, and 2 found in favour of the claimants, and there was 1 dissenting judgment from Lord Justice Underhill. Now, as part of the legal team representing the drivers, having Lord Justice Underhill dissent was a nervous moment, because he is a very respected employment law specialist. And what he said was that Uber is no different from the traditional minicab firms that have existed over the past 30 years. The differentiating feature is that they have scale, they're much bigger. But within the minicab trade for decades, it has been the case that the drivers are self-employed, and that in effect, the cab companies act as an agent, and they are a conduit for work. They find work for the drivers. He also went on to say that you can only depart from what the contract says if the facts point to the contract being an absolute fiction. And given that Uber, its model replicated or reflected the wider cab trade, it couldn't be characterized as artificial, and therefore there was no authority, there was no mandate for the courts to simply strike through the contract and reinterpret the bargain. So that takes us to the Court of Appeal. Then it moves up to the Supreme Court, and we're before seven justices of the Supreme Court, and the leading judgment is given by Lord Leggett. And Lord Leggett's judgment went much further than any of us anticipated, acting for the drivers. And it was really an almost moving in parts judgment, because what he was saying is, let's almost park what the contract says. The contract is important. Yes, as lawyers, we have to try and ascertain what the contractual relationships are. But this, and again, this is something that Matthew recognized in the work that he did very well. There is a huge imbalance in power between people who are earning very little, who have limited options within the employment market, and large national and international companies who are setting the terms of the contract. And really what the focus should be on is what is the purpose of the legislation. Let's look back to the legislation and identify what the purpose is. And the purpose of the Employment Rights Act and all of the other legislation that mirrors the definition of worker is to protect people who are vulnerable to exploitation, and to make sure that a safety net is put in place. He takes that as his starting point. He takes that as the touchstone for interpreting relationships, and then looked at the facts of the case, and he agreed with the majority of the judges before him. The contracts were highly fictitious. There was a dependent work relationship. There was a high level of control. The only way in which Uber can standardize the service that it is delivering is to ensure that every facet of that interaction with Uber is controlled and is uniform from the perspective of the client. And for those reasons, he found that that the Uber drivers are workers. So where does that leave us? Well, contract has become secondary. That's the first thing. And I've lost count of the number of times a client has said to me, here is a contract, can you please fine tune it to make sure that the individuals that we employ are self-employed? And that is just not a realistic way to manage your business, to construct a model for engagement. And it is not something that the courts are going to accept at face value. What they are going to look at is the reality on the ground, and in particular, whether there is a dynamic of vulnerability on the part of the workers. So contract has almost become secondary and statutory purpose has become primary. They then looked at working time. When is somebody working? And I think this is a live issue, but some helpful guidance was given. Clearly, where you have gig work, it is intermittent. You're picking up job after job, depending on demand. But I think what the Uber judgment sends a signal out to the market with is that these companies are going to have to more responsibly manage demand. Because if you've got, as part of your business model, a pool of resource sitting idle, waiting for work, there is a very strong argument that they are working the whole time that they're waiting for work to be allocated. In other words, the companies can't take all the benefit of having this huge pool of resource whilst not having to pay for the time of the people who are waiting for that work. A live issue that was unresolved because the case centered on the circumstances in 2016 is what happens where you have multi-apping, where you have drivers or riders with a number of different apps open, and they're flitting between the various apps to accept work. That is an open question. My view is that I think the way the law will develop in a way that is essentially protective. I think the people working, let's take food delivery cyclists and riders. It is precarious work. It is hard work. It is low paid. They are vulnerable. They do need that safety net. And I think that the arguments that will prevail is that it is for the various gig companies to resolve how intermittent work is managed. But what can't happen as a consequence of that multiplicity of apps is that people fall outside of that safety net. Two other points before I conclude. The first is I just want to touch on IR35. Now, you've got some expert speakers coming up who will speak to this authoritatively. For my part, I don't think Uber has much to say about IR35. The IR35 tax regime has a completely different purpose to the protective purpose that is embedded in the Employment Rights Act. And given that the Uber judgment is all about statutory purpose and purposeful construction, I don't see that it has much to say in the realm of tax, where a different purpose, a different social policy is being pursued. As Elizabeth said at the outset, in any case, the two regimes don't match up perfectly. You've got a three-category test in employment, you've got a binary test in tax, and the two don't cohere as well as perhaps they should. And so a very granular analysis of worker categorization doesn't speak to the tax test where worker has little or no currency at all. Final health warning before I wrap up. The sting in the tail of the Uber judgment is around the way the national minimum wage is defined, and in particular, the way expenses are treated for the purposes of calculating the national minimum wage. There is a strong argument that people in the position of drivers who are having to pay for fuel and vehicle hire, that those costs need to be offset before you calculate what the national minimum wage is. And I think that makes Uber's exposure and companies operating in a similar way really quite vast it isn't just a back claim in respect of wages that haven't met national minimums. It isn't just about unpaid rest break and annual leave. It could be that the very business model, the way that expenses are borne and who they're borne by, manifests in presenting huge back pay claims to those types of organizations. I think the lesson for anyone listening is that the game is up, I think, to a large extent. What I am seeing is the Uber judgment landed very quickly. There is an attempt to bring similar class actions against other big gig employers, Deliveroo being the first likely next class action. But it will affect all companies, I think, as people become more aware that there are these back pay claims. So, Deutsche Bank estimated that the tax consequence of the judgment against Uber was 1.5 billion. They have already offered their drivers 500 million in terms of back pay, and that doesn't address all of the losses they've suffered. So it's a cautionary note, it's a cautionary tale. And I think if you are an organization and you have modeled your business around essentially miscategorization, you really need to put your house in order and take note of the judgment. That's all I wanted to say by way of introduction.
Thank you so much, Paul. We do have time for a couple of questions. We have a couple in already, so if you're happy to take those, Paul, that would be fantastic. And I understand that you're also going to wait and join the panel in a little while too. So thank you for that. We're going to put Paul's LinkedIn details in the chat too, so anyone that feels a little bit shy today, please feel free to contact him on LinkedIn, if that's all right with you, Paul, she said, having just announced it. Thank you. Okay, your first question from Duncan Brown. Paul, the government has said it will be simplifying employment status. Do you feel that removing worker status and defining status so as to be aligned with the two definitions for tax purposes would improve the situation and prevent deliberate manipulation of status by employers like Uber?
Yes, I think it probably would simplify things. I mean, look, I'm not nearly smart enough to be a policy guru or to track forwards from where to see where we go next. But I think there is an upside to simplifying, which is that you get round all of this weight of case law, the complexity of navigating the difference between worker and employee. It's not at all clear. I mean, I think it's very clear how you differentiate between a worker and someone who's self-employed. I think those tests are well established. I think they are easy to follow if people are operating in a straightforward and honest way. Most of the case law, whether it's Pimlico Plumbers or Addison Lee or City Sprint or Uber, that those are very clearly boundary manipulations. People have set out to play the system, and the courts are alive to it. What is much harder to differentiate between is an employee and a worker, because the leading case on it is Windle, and what the courts have said is, well, they're essentially, the test is the same, but the pass mark is slightly lower for a worker. And I think that's quite hard to navigate. I think it's hard to differentiate. So the best answer I can give to that, and it's pretty inadequate, is I can see that there are attractions to simplifying the test and making it binary. I can see that that might make it more compatible with the tax regime. My only concern is that it might in some way interfere with the more casual type of work that businesses want to engage people to do, and indeed that people want to do. You know, people don't necessarily want to be an employee. They might want a more fluid arrangement. So yes, it's a difficult issue, and I think there are pros and cons both sides, and probably the other speakers can say something slightly more intelligent about that.
Thank you very much, Paul. I'm going to introduce the panel now. We're delighted to be joined today by Matthew Taylor, CBE, who's a British former political strategist and currently Chief Executive of the Royal Society for the Encouragement of Arts, Manufactures and Commerce. In 2005, Matthew was appointed by Tony Blair as head of the No. 10 Policy Unit. In October 2016, he was appointed chair of the Review of Modern Employment established by Theresa May. The Taylor Review report Good Work was published in 2017, and Matthew is a writer, public speaker and broadcaster who has been who's been a panelist on Radio 4's The Moral Maze since 2008. Welcome, Matthew. Also, Dave Chaplin, the CEO and founder of contracting authority Contractor Calculator and tax compliance firm IR35 Shield. Dave's the author of the Contractor's Handbook 3rd edition, and more recently IR35 and Off-Roll Payroll Explained. It's a good read for all of us. He assists with IR35 tax tribunals and has consulted on many occasions for HMRC. He advises politicians and government bodies on freelance tax matters and is prolifically quoted in the trade and national press. We also have Rebecca Seeley-Harris, an employment status of payroll and IR35 expert from Re Legal Consulting Limited. She is a member of the tax faculty of the ICAEW, a consultant to the British University's Finance Directors Group, amongst others. She's recently written a book called CEST Explained, and during the pandemic, Rebecca drafted the Directors Income Support Scheme and the Targeted Income Grant Scheme, and worked with the FSB, the ACCA, and the All-Party Parliamentary Group for Gaps in Support. And Juliet Eccleston is the CEO and founder of Any Good, which was launched in 2017 and now provides personally recommended candidates to organisations across the UK and beyond. Juliet is also the chair of Sharing Economy UK, the trade body for sharing platforms, which works in partnership with the CVI. Juliet supports the growth of the sharing economy, maximising and highlighting the economic, social, and environmental impact, enabling business and the economy to reach its true potential. And she's actively involved in providing input into government regulation, policy, and proposed taxation of platforms. I am thoroughly intimidated by all of you. We're going to hear firstly from each of the panelists and then open up the debate more widely. So do keep your questions and comments coming in on the chat, and feel free to raise your hand if you would like to comment in person. Rebecca, we're going to hear from you first. I'm sorry, Rebecca, you'll need to unmute yourself. Sorry.
It's always a big problem with these calls, is it? Still haven't got used to it. Anyway, thank you, Paul, for your very insightful information there. Last week, the Court of Appeal gave judgment in the Addison Lee and Lang case, which had been stayed pending the outcome of the Uber case. Addison Lee had been asking for permission to appeal the Employment Appeal Tribunal judgment, and this has gone back to 2017, so it's taken quite a while for them to get to this point. Their drivers had been considered workers at the EAT. The court decided that there was no reasonable prospect of success based on the outcome of the Uber judgment, so the appeal was denied, and this was without a full hearing. So although the Uber and Addison Lee cases were very closely linked on the facts, this does appear to be the direction of travel for these gig economy companies and for platforms in general. And I think it'll be interesting to see whether the gig platforms now elect to treat their workers as workers, for LIMBY workers, rather than waiting for tribunal action, which takes a lot of time and a great cost. So the practical effect of the judgment, as we know, is Uber has eventually decided to give all of its drivers workers' rights. By the way, Uber technically didn't have to follow the judgment for those, only for those that brought the case, not for the wider workforce. And this is an issue because obviously they then have a dilemma. Do they roll it out to the entire, I think it's 40,000 drivers, but they did do. So for me, the most interesting part of the decision is how Uber have dealt with holiday pay. And holiday pay for workers with variable working patterns is very difficult to administer in practice. Using the rolled up holiday pay whilst a practical solution is actually unlawful at EU level, but was never in fact transposed into UK law. So, but I think it's generally accepted that you can't use the rolled up holiday pay method. And in fact, HMRC advise against it. So Uber, to ensure that they can retain the flexibility of the job with no mutuality of obligations, are giving holiday pay when the contract terminates at the end of each weekly contract. And this is in fact lawful under the normal accrued method of paying holiday pay. And in fact, actually, I think it's quite a clever solution on their part. But Uber are not the first company to make the decision to give workers basic employment rights. In fact, in 2018, following a defeat in court on workers' rights, Hermes reached a recognition deal with the GMB Union to give their couriers the self-employed plus model. And this means, again, that the couriers continue to be self-employed for tax for basic rights. That, again, was a situation where the GMB Union were talking to Hermes and saying, well, you know, you've lost the case, but it doesn't have to be rolled out to all your workers. So, you know, just do the right thing. And they did. Unlike Uber, Hermes have opted for a system where the courier can opt to be either self-employed or to be self-employed plus. I'm not entirely sure how they distinguish between the two, and that is actually quite an important factor from a tax point of view. But both systems have ensured that they continue the flexibility in order, I'm assuming, that they avoid HMRC bringing a case for employment status for tax purposes. So the contentious issue for me is that whilst the drivers now have basic employment rights, the judgment does not extend to and has no bearing on the status for tax purposes. And as Paul mentioned, although there is a third category for employment rights purposes, that of worker, there is no comparable category in tax, only that of employed or self-employed. So the problem from HMRC's point of view is that the threshold for proving that the drivers were employees as opposed to workers is too high. So any court action would likely fail. The effect of the mismatch of the classification is that the engager does not pay employers' national insurance contributions, nor does the driver pay the income tax or employees' national insurance contributions. This is obviously a significant loss to the Treasury, especially the employers' NICs at 13.8%. This is a problem that has existed for a long time, but it has only come to the fore more recently because of the amount of workers' rights cases that we're seeing. It is an important issue, but it's not one that's going to be solved easily. And in fact, when I was a senior policy advisor at the Office of Tax Simplification, which is an independent review body of HM Treasury, we were asked specifically to look at the issue of how the problem was going to be solved for tax purposes. Should there be 3 categories for tax, perhaps, to bring it in line with employment rights, or should we get rid of the worker status? That's too complex an issue to discuss right now. But indeed, it's not the first time that this is being considered, and it won't be the last. In 2007, HM Treasury did an evidence-based assessment. The Merleys review looked at the issue in 2010. There was a call for evidence in 2011 to discuss what the options were. And again, the IFS Green Budget in 2015 mentioned it. And I know that a lot of economists, for example, think that all labour should be taxed equally, but it's not been a solution that's been approved by either the OTS, the Treasury, or the government. Otherwise, they would have adopted the solution before now. The problem is that the issue of employment status for tax purposes and for employment rights purposes are separate and distinct, and you won't, in my opinion, solve one without the other. It does still, however, remain a problem for the government, and no doubt they're going to have to tackle it at some point. Thank you.
Fantastic, thank you very much indeed. Dave, would you like to contribute?
Sure, yes, thank you for inviting me to this forum. This weekend, my wife and I both watched The Godfather 1 and 2. And there's a phrase in there that Don Corleone says, which is, can you hear me? Everyone hear me?
Yes, we can. Thank you.
Okay, there's a phrase in there that Don Corleone says, and I won't do the Marlon Brando impression, that is, I'm going to give him an offer that he can't refuse. And that reminds me of all these precarious workers, and it's that cohort of workers that, okay, they're not having horses' heads put in their beds or guns to their heads, but they are in a position where they're given a Hobson's choice. These are the terms, take it or leave it. And this is what Uber is helping to solve. But then when we look at Uber, and we look at lots of those taxi drivers, and I've taken many Uber taxis over the years, I've taken many other taxis, and I always end up having a conversation about status. And there's 2 groups of people. There's ones that are quite happy to be self-employed and work when they want and have the choice and refuse. And then there's the others that feel that because they're doing it for 50 plus hours a week, that they should have rights. So there's something there about choice. 5 key points I would make around the areas of tax and rights are that I think the workers that should get rights that should have them should get them, and they shouldn't have to go all the way to the Supreme Court to get them. They should be automatic, and obviously the legislation and statute should be there to support that. And it's wrong that precarious workers are being forced into situations of false self-employment because they have little or no bargaining power. But then there's the other cohort of people, which tends to be sort of my gang, which is they're at the higher end of the pay scale where the bargaining power has flipped. And they're earning more money. They're quite happy to have no rights. Someone who's on £500 a day is not someone who's a precarious worker. They're not vulnerable. They're not subordinate. And I don't think they're in a situation where really there should be an intervention by the state on either matters of rights or tax. They should have the freedom to choose what they want to do. Now, in terms of the same levels of tax, should the self-employed pay the same amount as the employed? Well, they sort of already do. It's very close. But as Matthew kindly quoted me in his report, the £60 billion elephant in the room is employers' national insurance contributions. And that's the issue that HMRC have. It's the issue the government have. And they're essentially concerned that more and more people move to self-employment, and that slice of the pie that they get in the transaction is getting smaller. So yes, something maybe needs to be done. In terms of aligning rights and tax, I don't think putting worker as a status into the tax regime is a smart move, because it just creates even more complexity, and it's bad enough as it is. And I would support the removal of worker status from the employment rights sector, provided it was done in conjunction with changes to prevent the exploitation of precarious workers and people being given offers that they can't refuse. So that's where I sort of stand on those things. But when it comes to the tax area in particular, we're in rather a pickle at the moment, because the IR35 legislation that's been around for 20 years, it failed for 20 years, and we introduced off payroll, and that has not gone very well at all, and will continue to fail in my view. I don't think it will create or raise any meaningful amount of tax compared to the disruption that it's causing. Although I would say that looking at the emerging case law that will come over the next year or so, I think there will be more certainty for firms to be able to hire contractors and not worry about being chased by HMRC at a later date. But we do have a real mess, and some of the things we're seeing is to sidestep these new off-payroll rules. One of them we're seeing is that UK contractors are now seeking to work remotely for overseas companies so that the new Chapter 10 rules don't apply. And we're seeing UK-based companies seeking to hire their workers from overseas, so they're not subject to the Chapter 10 rules. And we've got this bizarre situation where the rule is don't work for someone in your own country. We've also got case law that's happened recently, whereby we had a particular media presenter where all the traditional pointers for employment were present, but they were found to be not an employee for tax purposes and outside IR35 because they were in business on their own account. Now, I'm very close to that case and have been for a while, and I can tell you it's going to the Court of Appeal. And the problem with that is that, well, that makes it almost impossible for a firm to assess whether a contractor is outside IR35 without rummaging through 20 years of their whole history of what they've worked on to decide whether or not they are in business on their own account, which then really it demonstrates that there's an underlying flaw with the new legislation, which makes firms decide what the status is. And the third mess that has happened as a result of the new off-payroll legislation is that many workers are being pushed into false employment, and they're being pushed to use unregulated umbrella companies, which is a market that's been described recently by an APPG as the Wild West. And the more non-compliant an umbrella company is, the more money it makes by being non-compliant, the more money they can give to an agency in kickbacks to then encourage more contractors to then go on their books. So we now have an unregulated market where profits are driving tax evasion, tax avoidance, and a second loan charge fiasco is potentially on the cards. So what is the solution? At the tax level, I think people should have the freedom to contract. There should not be any sort of backdrop of statute, and HMRC should not be able to intervene. The parties are grown ups, they've decided what they want to do, and the tax is paid accordingly. If they want to raise more tax, then raise taxes. That's fine by me. I'm happy for them to be in parity, or perhaps, as many of us have suggested for years, you introduce a sort of 2 or 3% hires tax across the board. That might be simpler. At the rights level, I would say, this is my closing point, I think better legislation is needed to ensure rights cannot be circumvented by armies of lawyers, but we need fine-tuning of the legislation now to align with the statute.
Thanks very much indeed, Dave. Matthew, your thoughts, please?
Thanks. Well, it's great to be here. I've not been doing the work on this for some time, but these conversations remind me a great deal of the conversations that we had with officials as we were doing the review. And I found what Paul, Mareka and David has said fascinating. I want to say, by the way, for those people who are listening who think, well, this is a typical example of muddle in our system, these are issues in every labour market, as far as I can tell. So these questions of status and the interaction of tax and labour protection are issues in almost all jurisdictions, and nobody has got it perfect. I think if anybody had solved this problem once and for all, then you would have seen that model taken up everywhere. But it is a challenge, it's a problem everywhere. I also just want to say that I think Dave's absolutely right about some of the other issues that we need to attend to. The scope for international arbitrage, I think, is significant. And, if you can work from home, you can work from anywhere. And so that may well grow as an issue. And he's also absolutely right about the issue of umbrellas. Umbrellas are now regulated as one of my recommendations, but unfortunately, the government has not given any additional resource. So it's very unclear how that regulation of umbrellas is actually going to take place. I mean, I'll just take one step back because I've only got 3 or 4 minutes and just remind us in a sense of what are the criteria by which we would want to judge ultimately the effectiveness of the system. And I'd suggest 4 criteria. So first, public good. And as I think all the other speakers have mentioned, one of the kind of big public good issues here. So that is the good for the whole of the public, not just for those people who are in one way or another involved in these issues around the labour market. There is a big fiscal question. And I think I'm right in saying that a sole trader on average earnings generates £3,000 less in revenue than an employee on average earnings. And that's not a sustainable position. Self-employment seems to have topped off, but it had been, rising quite substantially until recently. And certainly, if you talk to Treasury officials, I mean, I was surprised in my review that I had quite positive conversations with Treasury officials. Didn't really expect it, as I was kind of in danger of increasing regulation. We know what the Treasury feels about regulation, but they were quite keen on my review because of this, and they were very keen to show me lots of charts explaining this kind of fiscal black hole. So there's a kind of public good. One of the key public good here is a system which generates sufficient taxation, and that's always going to be a very important consideration, perhaps not one that politicians talk about nearly as much as officials do. Secondly, justice and protection for the vulnerable, and we've heard a bit about that, particularly from Paul, fantastic work that he's done. So how do we make sure that people aren't being ripped off, exploited, badly treated? But there's also an issue about, I would say, about the self-employed and the vulnerabilities of the self-employed, which have been highlighted a bit during COVID. It's worth remembering that you're 3 times as likely to have suffered a significant decline in your income during the COVID pandemic if you're if you're not an employee. To say you don't have that full suite of rights. You're either a worker or self-employed. Third, I think, aim is market efficiency. And that is to say that we want companies to succeed because they invest, because they innovate, because they're well led, because they have great products, not because of their capacity to arbitrage the system. And we have a problem with productivity in this country. We're not going to improve our productivity if the best way to make your business profitable is to get a dodgy accountant or lawyer to help you game the system, rather than thinking about how you can develop fantastic products or attract new investment. And then finally, we want the law to be simple and understandable as far as possible. It's never going to be completely simple, and it's always going to require lawyers to help us understand it. But we should make it as simple and understandable as possible. And that's why, to conclude, I do think, and I recognize that there's no, if there was a public policy proposal out there that didn't have any downsides, it would have been implemented a long time ago. So everything's got downsides, and the way you implement things is a very important part of whether or not they work. But nevertheless, I believe, as I argued in my review, that we should try to align the tax system and the employment regulation system. I think that the third of Paul's criteria should be really the primary one. You should only turn to substitution if the primary criteria is not decisive, and that criteria should be the same as it is for tax, which is really basically the way I would put it, is control and supervision. Are you subject to ongoing control and supervision in your role? If you are, then HMRC will say that you are, as far as they're concerned, an employee for tax purposes, or you are employing somebody for tax purposes. And I think it should be the same for employment regulation. I would, and this is not a view I'd come to in my review, but it's a review I'd come to subsequently, I would argue, I would accept the idea that there should just be two statuses, which goes along with that idea. We get rid of the worker status. I understand the point about the danger that reduces the scope for casual work, but the key employment rights, particularly unfair dismissal, you only accrue them over time anyway. So it seems to me quite possible to say that, with the accrual of rights over time, it doesn't stop you employing someone on a casual basis and not having to find yourself in a situation where if you want to let go of them, we haven't got any more work for them, you find yourself dragged through an employment tribunal or whatever. So I think that's a problem we can solve and still have casual work. It would make the system simpler. It would remove incentives. Those changes, if implemented properly, would make the system simpler. They'd remove most of the incentives for arbitrage and exploitation. If you did this, if you were to, at the same time, going to what Rebecca said, have tax all labour at the same level, which is the other side of this recommendation, you tax labour all at the same level, then you will generate more revenue through that. And some of that revenue, in my view, should be used to strengthen entitlements and protection, or entitlements for self-employed people. So if we, as the employers of self-employed people, had to pay a tax on their labour, some of that tax, not necessarily individually hypothecated, but some of that tax could go to a pot which could, for example, improve a protection for self-employed people in terms of sickness insurance, or training, or pensions. Self-employed people don't save enough for their pensions. So I think you could also improve the position of the vulnerability of some self-employed people. Now, that shift to two statuses, the same criteria, and a common tax basis for the taxing of labour. You can still, by the way, give tax incentives to self-employed people. You can give them tax for allowances for their equipment. This is not about how much the individual pays, it's how much we as the hirers pay. If you did all of that, I think it would make the system better. Should you do it overnight? No. But I think what the government should do is indicate that's the direction of travel over the next decade, and then gradually get to that point. And that has the advantage, which is by the time you get to that point, most people have adjusted to the new system anyway.
Thank you, Matthew. And Juliet, thank you for your patience. We'd like to hear from you now.
Thank you so much. Yes, so I'm chair of Sharing Economy UK, which is the trade body for sharing platforms. Really through the lens of the platform, what we see is an awful lot of very different business models that no doubt will get tested at some point. As Paul was saying, I think what we are focusing on with our platforms is to encourage them to look at the worker status and the various cases that are coming up and be proactive in their work around looking at the workers that they have and how they should apply the rulings that are coming out. One of the things that is a challenge for platforms is that we do continue to innovate, and we are always coming up with new ways of working, whether it's obviously Uber is the case that's talking about today, but from a sharing economy perspective, there are many more models than that, whether it's Airbnb or TaskRabbit or Borrow My Doggy or Rent My Clothes or Rent My Tent. There are so many different models, and really all of these are very innovative in how they work, and so therefore they will be constantly testing legislation and ending up in the courts if the law isn't flexible enough to handle the different worker statuses that come through. That really relates to my three concerns. One of my first concern is really that that one or in effect two sizes doesn't really fit all. We see so many different variants and different ways that people want to work from a micro-entrepreneur perspective. Secondly, the lack of clarity over what the legislation means in practice. And again, Paul referenced this in terms of when you have multiple workers using various different platforms and working across multiple platforms. Some of them may be all drivers for various different organisations, and how that works. And we're very keen to work much more closely with the government through the CBI in order to help with clarification as to how that can work in practice. And thirdly, there's a lack of awareness that we've seen from HMRC and Treasury around the various business models that we have within the sharing economy and within marketplaces generally. We're working with the government across multiple different tax aspects, from VAT through to things such as workers' rights, digital tax, and what we generally see in these conversations is that the models of Airbnb, Uber, and TaskRabbit and Deliveroo are the ones that are generally used as examples, but there are so many more than that. And also the impact of taxation on the platforms themselves in terms of the positive impact of platforms when you start to look at things not only through COVID, but beyond that, around the impact from a social impact perspective, environment perspective. When you look at taxation, for example, of car sharing companies, and the impact that those have on the environment, where we have 5% of emissions being due to commuting. For clothes rental, we have 11 million garments going into landfill every week. So looking at what we need really to do is to look at the broader implications of taxation of platforms with government, and make sure that we're considering the whole of the taxation landscape, rather than just sort of individual taxation cases that come through. So just summing up, really, it's for me, it's really making sure that the government really do have an understanding of the broad aspect, and not isolated cases that come up and then go through the courts. We'd really like to work much more closely with them on that.
Thanks, Juliet. Rebecca, you're nodding. Is there anything you'd like to add?
Well, I think for me, the main problem is looking at the wider scope of the whole of the sort of taxation of self-employed, IR35 off payroll, because we've got a massive problem now with off payroll being brought in. You've got people who are paying tax as deemed employees with no employment rights. You've now got a class of worker who is getting basic employment rights being taxed as a self-employed person. You've also got this situation with the umbrella workers who are technically employed, but they're not getting the employment rights that they should be, especially during the pandemic. They're not getting holiday pay. Not all umbrellas, I have to mention that, but we have a situation where the non-permanently employed, whether you call them the self-employed, people who work for themselves, they're all very different. And now we have multiple classes of taxation, multiple classes of employment rights, workers' rights who are not employees, employees who have full rights. It's a mess. The problem is the government has all this information, multiple reviews being done, Matthew's review. When I was working at the ATS, we did the employment status review. A lot of work has been done on taxation. There's a lot of lobbying being done by Dave and other people, Juliet's contribution. It's time that the government actually consolidates all these reviews, looks at it again, have a working group, have a cross-government working group. They have actually got one, a cross-government working group on employment status. Bring that back, make the departments look at this in its entirety and make a decision and bring in regulation one way or another so there's more certainty for business.
I think the problem here, and this is something that is pretty consistent with this government, and I'm not saying they're particularly worse than other governments, but it's that combination of inertia and ideology. So, there's inertia because this is complex and it would involve departments working together and involve number 10, the Treasury, Bays, MOJ working together. It's MOJ or Home Office, Home Office working together, you know, because you've got multiple angles on these questions of enforcement and all that kind of stuff. So you got that. It's complicated, it's difficult. Who wants to do it? If you're a minister, if you start the process, you're unlikely to be the person who sees it out. And then politically, you know, there's a terror of what happened to Philip Hammond, you know, where, you know, just so people know, what basically George Osborne gave the self-employed pension rights, and at that time he absolutely ought to have. It's a completely unbelievable error that he didn't at the same time increase national insurance payments by self-employed people, as he was giving them a big kind of freebie. He didn't do it. Philip Hammond tried to address the fact that self-employed people were now getting pretty similar welfare entitlements. I'm sorry, it's a delivery inevitably. Hopefully the person's a worker. And then when Philip Hammond tried to do something that was completely rational, completely logical, you know, it kind of destroyed his credibility. So, you know, that's why I think the way to go about this is to kind of indicate where the government wants to be in 10 years' time, and to do this step by step. You could, for example, start with a 5%. You could either massively lower the VAT threshold, because we've got one of the highest VAT thresholds, which is another part of this story, or else you could just introduce a 5% tax on self-employed labour that we would all pay when we paid our gardeners or cleaners or whatever, you know, a 5% tax on self-employed labour, and you could gradually build towards this. But Rebecca's right. The inertia over the last 15 years has been incredible. I mean, everyone's known about this, everyone does know about it. And we all had a bit of hope when the Chancellor unveiled the self-employed support scheme at the beginning of the COVID, because when he unveiled that scheme, he said, we do need to look again at self-employed taxation. We waited in the budget to see whether he would, he'd come through on that, and he obviously had backed away from it.
Thank you, Matthew. Dave, over to you.
Yes, I think there's, I actually don't think there are people avoiding tax in the cohort of contractors where they have an equal or higher amount of bargaining power themselves. Because, and when you look at lots of the reports that come out from government and some of the think tanks, they always try and compare the amount of money someone's earning when they are self-employed compared to what they would be earning when they're employed, and they always put them at the same amount. Well, that's just simply not true. And it's a fundamental flaw with lots of this analysis, which is to assume that someone that's self-employed charges the same amount as their permanent counterpart. It's just simply not true. So we need to start looking at the amount of tax someone pays in pounds rather than percentages, and the self-employed do pay a lot more. But because we have this such a disparity of the levels of tax, it does create this position where firms can make money by exploiting workers, but those ones that are exploited are the ones where they don't have the bargaining power, so they're not getting the rights and so on. But if we put them into a position where they had to become employees and they were getting the rights, then they can't be pushed into false self-employment, and we fixed that problem. For everybody else, where both parties have agreed, people have entered into contracts in good faith, I think they should be left alone so that they have tax certainty. Because at the moment, the uncertainty around the tax system with off payroll is really damaging UK PLC, and firms are just pushing work offshore and not using UK workers. It's very damaging.
Thank you, Dave. We are slightly running out of time, but Juliet and Paul, if we could just briefly hear your closing thoughts, that would be lovely.
Thank you. Yeah, I'll go, and then Paul can perhaps sum up. Yeah, I mean, I think from our perspective, it's always going to be a trade-off between flexibility and security, and that's not just for the worker, but that's also for the platform. And the majority of platforms are really trying to do the right thing, but to do the right thing, they need clarity over what that right thing is, and that's what we'd like to see moving forwards. Paul, over to you.
Well, it's been fascinating and really, really interesting to hear on the tax angle in particular. My experience is that the organisations that seek to classify people in the Employment Tribunal as self-employed often aren't trying to do the right thing. I think there's a very conscious attempt to misclassify, and there'd be a lot less litigation if that wasn't happening. In the City Sprint case, after we succeeded in showing that Margaret Dewhurst, the cyclist, was a worker, they ran the point to appeal, and then on the week of the appeal withdrew the appeal and said, well, it no longer applies because we've changed the contract. And that sort of abuse is very brazen it's sort of about wearing down opponents and making sure that, you know, there's this sort of constant evasive adaptation of a model so that a judgment doesn't have a bearing on the wider workforce. Maybe the sensible answer is, as Matthew said, this sort of harmonization or simplification. I mean, that was very persuasive. But until that happens, there needs to be a much stronger centralized enforcement of abuses that are happening. I mean, if you've got a flagship business like Uber that can avoid its responsibilities for 6 years and then seek to settle it largely on its own terms, it really is asymmetric. You've got low-paid people relying on pro bono lawyers and trade unions to try and assert basic rights, and that just isn't viable or right in the short term. So whilst we're waiting for government to get its act together and to come to a sort of coherent position, I think some centralized power to stop vulnerable people being exploited would be a very good step.
Fantastic. Thank you very much. Indeed. Sadly, we are out of time today. Thank you to all of you for your very lively, interesting contributions, and to Sam and Ellie behind the scenes for making this all look so seamless. We have put a brief survey in the chat. We'd love to hear what you think of today's content and any other areas you feel we should be examining. We will be returning to this fascinating subject in a month or two, so we'll make sure you get sent all of the details of that. Thank you very much indeed for your attention, and we will see you the next time. Thanks.